We'll go ahead and call the meeting to order. We got 1:05 p.m. And we'll call members.
Constable Sean Kennington,
Here remotely.
Constable Sean Kennington,
He's here, just
Here.
not picking up on your guys.
Chief Mike Harmon.
Here.
Judge Stephen Abels. Chief Robert Crawford,
He's here online as well.
Curtis Howard.
Here.
Kevin Lawrence.
Here.
Leonard.
Here.
Lieutenant Lizette Rivera. Here. Dr. Jonathan Scheinberg. Dr. Stephen Tate.
Here.
Clay Taylor.
Here.
Sheriff John Wayne Valdez.
Here remotely.
Thank you. We have a quorum.
All right, well, thanks for everybody being here and those that are online participating. Not sure if we're gonna make it over here or not with the traffic going on. Little incident going on around the area, so I'm glad everybody made it, took time out of your schedule to be here. We'll move on to number 2, approval of minutes for the November 9th, 2023 Advisory Committee. Motion.
So moved. Second.
All in favor, say aye.
Aye.
Those opposed, say nay. Alright, motion carries. Approval of the minutes approved for November 9th, 2023. Next, we'll move into our number 3, subcommittee recommendations for minimum standards. Last meeting, we did split into 2 committees, one dealing with physical fit for duty, the other one psychological fit for duty. First up on the list is the physically fit for duty. And we got some information that we gathered. It was the determination that none of us really had any good documents moving forward. I've experienced that myself at our agency as far as what a physical fit for duty looks like moving forward. Dr. Scheinberg was able to produce the documents, and I believe everybody has a copy of them. Again, these are, we're just setting minimum standards. Any agency can improve or tweak it a little bit, but I think the main topic is setting minimum standards for what a physical fit for duty, pre-employment, and then if you're injured and coming back into the line of duty. Is that correct? So the first one, the medical release, physical fit for duty, pretty basic, self-explanatory. There may be some things in there that we want to tweak up and look at. And then, of course, you got your medical history form, replacement examination for law enforcement. This is actually pretty detailed, more so than what our agency offers. A lot of things in here that I do like, and if y'all haven't had a chance to look through it yet, feel free to do so and make any comments. And then the last, or the other document is a pre-employment physical examination form. And this is exactly kind of what we were looking for when we had to do one here recently. We wanted a more in-depth form, and this one gets pretty extensive looking through there, so you can look through there. I think these documents right here are what we're looking for. Again, they can be tweaked, add, delete, but as far as setting a minimum standard for TCOL, I think this is a good start for this committee. Comments, questions?
I wasn't here for the last meeting, so have we changed the purpose of the committee? Are we setting minimum physical fitness standards for all law enforcement officers across the state, and now T. Cole's gonna enforce that? Or is this simply a review of somebody that there's a question that's been brought up about their fitness for duty for some specific reason?
Are you talking about specifically setting a standard? The purpose is the statutory charges set standards and procedures. So what we did is split it up into two committees, a physical and psychological side. We're setting that standard, the basic standard, some kind of standard. I think we discussed it in the first meeting, which you were at. And I remember you had some good input on actually when we were talking about that. So yeah, those subcommittees would come up with some kind of standard that we could at least discuss moving forward. I mean, I think as the chief said, it doesn't necessarily have to be, this is for tweak and review, but you've gotta have some kind of discussion because it does set standards and procedures. So if that standard is a general standard, so be it, but certainly within the committee's purview to do so.
Okay, to set the minimum standards for hiring.
Yeah, to answer the other part of your question is for applicants and licensees.
Okay. So this would be used for applicants.
Could be.
Okay.
But are we talking about return to duty, fitness for duty as well? In this same entry level standard?
Yes, I think you can discuss that, absolutely.
I think the discussion last meeting, which also bled over into the psychological, is there is no guidance when people are going to the doctor or a physician, what I gathered. Especially on the psychological side, you've had folks go and 20-minute phone calls over their phone or a 30-minute in person, and you get a 3-line report saying, yeah, they're good to go, versus you go to somebody and get a more in-depth report on whether or not they're psychologically fit for duty. So I know we discussed that last time, and we're looking for some guidance on documentation or how to select doctors and stuff.
The question I think I'm confused about is, so an officer is on for 17 years, they break their leg, and are we saying that they have to go through an entire applicant level, entry level fitness for duty, physical, before they can be returned to duty, or is the doctor just checking their ankle to make sure that they have the proper range of motion and can support the weight and run on it?
Well, I think that's the topic of discussion is what do we want it to look like? What do we want the minimum standards to look like if somebody does get injured in the line of duty? And then they're at the point where they can come back to get sent to a doctor. Are they just taking a blood pressure and a pulse and saying you're good to go? Or are you actually going through some type of assessment to say, yeah, you're physically fit to go back to duty?
And I think, Rob, to your question, is it something, let's say the officer, the hypothetical that you propose, a 17-year officer, what do they have to, I don't necessarily think that the committee has even contemplated requiring that at the department level. Obviously, the department level's policies are the department level's policies. But I think it's more of the, maybe a health standard, and I think that was kind of the problems that we discussed in the first meeting was, is that person physically able to execute the duties of the job? And if they're outside of that very broad category, then what happens? And I think that's kind of where we're looking at is the scope within this committee as I understand it.
Okay. So then the next thing, sorry.
If I may, one of the things that we discussed in the subcommittee meeting was depending on what your job assignment is, for instance, if you're an investigator or you're a patrolman, your job descriptions are very, very different. The chances of you going to, I hate to use the word routine, but calls for service is much different than an investigator who's going out and doing follow-ups and situations like that. So what we need to decide, or at least come to some agreement upon is what that assessment's gonna look like if that person, that employee is mainly staying at a desk as opposed to riding around for 12 hours in a patrol car, making traffic stops and answering calls for service.
I guess I think the way I kind of see this committee is, we're, at least the psychological area that we're discussing is in the proposed policy that we have, do we want to reference what a professional should do? Understanding we are not professionals, and we're gonna leave that to the professionals to make that determination. One of the things that we found is there is a IACP has adopted a policy, model policy for psychological examinations, and basically looks at and references the evaluator's professional judgment and gives a kind of litany of things that can be done based on the appropriate circumstance. Because if you got in a medical situation, if you got a cardiac issue as opposed to an ankle issue, there's gonna be two different evaluations. We certainly don't wanna micromanage that process. So in this policy, do we want to have any references to some general guidelines an evaluator may have to follow? This is at least the way I see it, kind of the way it came out during our discussions.
Well, is there heartburn about having a minimum standards in place if you're injured in the line of duty and you're at the point to return? My personal feeling is there should be something in place to make sure that that police officer can still perform the job function of a police officer, whether they've been there 1 year, 17 years, or 25 years. As a chief, it's my responsibility to make sure that that officer is 100% before they go back out on the street, not only for the protection of himself, others in the department, but the community as well. So, am I hearing any arguments that that should not be something in place, or there should be something?
I would argue that an officer who goes out with a broken ankle shouldn't have to take a Cooper's test in order to get their job back. I think that if you look at your troops right now, no disrespect, Chief, but how many of them could really truly pass an academy level fitness for duty, stopping, to graduate the academy, you've got to pass this fitness exam. We all kind of slack after a certain amount of years.
Yeah,
The point is that if I know plenty of patrol officers who may be slightly overweight, can't run a 2-mile run anymore, but I wouldn't trade them for the best, fittest rookie in the world. Their ability to assess situations in the street, their ability to deal with the public at large. And I certainly don't want to create a worse situation. We can't hire as it is. The entire nation is in a hiring crisis for law enforcement. The last thing I want to do is have senior officers starting to show up with injuries because they're afraid to go out on injured leave because they're afraid they won't get back in once they get pushed out that door.
Trust me, we have no shortage of officers being afraid to go out on injury duty in our department. But, well, number one, we don't do the Cooper test at all. We have a validated agility course that they have to perform coming in. And then on an annual basis, we have to do either the agility course or the rower that we have standards set by. And we have a wellness policy in place. If they don't fail, or if they do fail, then there's criteria after that. But again, I'm not asking them to be Olympic athletes, but I am asking them to be able to perform the job functions of a police officer when they're going out there in the community. And I think that's the expectation of the public when they go out there. And I'll give you an example. The guy we had shot 3 years ago in the shoulder, in the arm. He went and got his, he was miraculously cleared. And we were like, well, we want an assessment. So we sent him to our doctor to make sure that his arm was fully functional and is able to grab and hold and do everything else. And he was able to perform that. But I didn't feel comfortable just going what his doctor said, because by his own admissions, there was a point he wasn't even able to lift his daughter or use that hand 100%. And I can't put somebody back out there on the street that's not able to perform. So,
But your example there is exactly what I'm saying. He had a shoulder injury, and you assessed him for a shoulder injury.
right.
And I don't think that that's really the issue. I'm asking, are we trying to say that there has to be a higher level of physical fitness rather than returning, let's say his assessment on the shoulder came back 100% cleared. He can do the work required. Would he also be required to do a 2-mile run and
No, that's
an
not part
agility?
of our system.
Okay,
The agility course is, because it's one of the obstacles is getting over a 6-foot wall.
Right, but that would be done on an annual basis
Sure,
anyway. That would be a
absolutely.
separate, it would be a process separate from this.
Right.
And agencies that have those things in place, and we've negotiated them into contracts where there's, and to answer your question, we don't disagree that our citizens have a right to expect their police officers to be in some semblance of decent physical shape. But we also understand that 20, 30 years on this job wears you down. So when you said they have to be 100% before I put them back on the streets, well, what if they were only 75% when they got hurt? Are we trying to get them back to 75%? Or are we trying to get them to a standard they couldn't have met before they got injured anyway?
Chief,
And is that standard, because I noticed this release that is included in here, and I realize these are here as samples.
Yeah.
But it says, I've read the description of the fitness test. I don't see the fitness test in here. So that would have to be sent over as well, right? We'd have to
Well, I
give
think
them the
that-
standards.
Yeah.
So, and, if I were, and I'm too old, but if I were to try to go back out and get a job as a law enforcement officer right now, there's things about me that, between a heart condition, hearing aids and glasses and whatever, just not gonna work.
Well, when I say 100%, what I mean is they're able to pass our agility course or whatever that we do on an annual basis, a timed agility
Right.
course, right? Because every obstacle in there is an obstacle that they would have to face in our city. Flights of stairs, apartments, 6-foot wall, fences, a window, dragging a 150-pound dummy,
And whatever that standard is still gonna be in place. They're still gonna have to meet that once they get back to work. I just think those are two different processes, and I think we shouldn't blur the line in this particular case.
I think we may be talking about two different things. One is a fitness standard and one is a medical examination. And I think, and Curtis, correct me if I'm wrong, I think one of the points is, and what came up in the discussion previously, is we send people to a doctor and the doctor doesn't have anything right now to look at unless they've come up with their own pre-employment thing. I think if you look at one of the handouts that says pre-placement physical exam, nowhere in this says that this is a disqualifier to service. It just says the doctor looks at the following things. So it gives the physician in this case a path to go down and make some judgments. It still goes back to the practitioner's judgment of this person's suitability, which it is now, but we don't know what they're looking at all.
Right, but to use Cedar Park as an example, and I don't mean to pick on you, but Cedar Park's already got a standard they've got in place they enforce on an annual basis. If an officer gets hurt, let's say Clay works for him, he breaks his leg, whatever, you send him to the doctor to make sure the leg is now recovered to the point that he should be able to go past that fitness standard. If he can't, that's a different issue. That's an internal departmental discipline thing. It should not be going to T-Cole for a fitness for duty evaluation. That's my argument.
And remember, that's the only time it comes to the state level if there's been that refusal to submit to that examination, which that's the only time it would come to TCO.
Or if they are found unfit for duty by a licensed professional, then it still comes to T-Cole, right?
Yes.
So my question is, are we asking this doctor to declare him unfit for duty, even though his leg is now recovered to the point that he can, in fact, he should be able to go take that test, whether or not he can pass it. This, may be problematic, and no offense, Clay, but
No, and I think to help the chief's clarification on what we did, these were all forms we got from Dr. Scheinberg, just as an example of what he would be looking at. And I made the point, and when we had our Zoom meeting last week, was that I used DPS as an example. DPS has a fitness criteria that was mandated by the legislature. Legislature only said you have to have a fitness program in place, okay, for all Schedule C. So what happened was DPS got on steroids and went to one extreme. Other Schedule C agencies said, okay, we're gonna stay down here. And I think that's perfectly fine, is what I told the sheriff during that conversation is I would expect a sheriff's department that has limited funds to have to meet that kind of standard. I don't know, does TCOL even have a standard right now with regards to physical fitness?
and should they?
And
Should
should
the
they?
standard be
Exactly.
same for a Dallas police officer working a beat versus somebody who works for the lottery commission?
And that was my point, was we don't wanna have to say, all right, all 250, every law enforcement agency in the state of Texas is now gonna have to meet this. These were just simply something that.
Including the officers that work for T-Cole, right? Because it is a police force.
Everybody.
And that's, I think, a great deal of the discussion last time. Certainly, I'm gonna defer to to Cullen, and I know the medical committees and the psychological discuss this. But I think it's a great point that you're bringing up about the Schedule C standards. But some agencies did some things and some may. Now, my question is, are those standards, enumerated in the statute, or is it just kind of handed it over and say, come up with a physical standard?
If you go back and look at the statute, it has not changed at all.
Yeah.
It's policy within each respective agency as to
Yeah.
what they're going to consider. This is a minimum standard. DPS right now is, I think, 75%. Whereas TABC may be 25%.
Sure.
Parks and Wildlife, I'm not sure where they are.
But the statute, and make sure I'm clear on this, is there's no enumeration of this is what the standard is.
That statute only says a Schedule C law enforcement officer has to have a physical fitness standard in place.
Yeah.
I thought y'all's was your waistline.
Well, that's an interesting comment because it's nowhere in the statute, but it's the department's policy that was just added on a couple of years ago that said, in addition to this, not only do you have to be 75%, but males have to have less than 40-inch waistline, females have to have less than 35-inch hips.
Sure.
So, that the outcome of that remains to be seen.
So I was just reading over some guidelines that IACP referenced, and it's kind of interesting how they phrase this. And I'll just read a couple of things. One's informed consent. I'm going to go through all of it, but this is the Fitness for Duty Evaluation Guidelines of 2018 regarding informed consent authorization for release information, which might tie a little bit into what we're talking about in some later. The examiner obtains informed consent of the examinee to participate in the examination. Common elements of informed consent include the following: a description of the nature and scope of the evaluation. Then in the next section, it talks about the evaluation process, and this wording could apply to medical or psychological. They didn't apply to that, but it's applied to psychological, but I think it applies in this conversation right now. Evaluation process 9.1, depending on the referral question and the examiner's professional judgment. And that to me is an important piece of information right there. And then it goes on to say, an FFDE examiner strives to utilize multiple methods of data sources to optimize the accuracy of the findings. And then it goes on. But I think it's important from this discussion that it's important to have the referral question laid out and given to the examiner. That's gonna help with what direction should we take, not this whole fitness for duty pre-evaluation that would take place. Is it an injury to the arm or the ankle? That's gonna give direction to the examiner and outline what the next protocol is gonna be, whether it's gonna be this test, that test, or whatever. So it leaves it open in that degree. I just wanted to put that out there.
I think the examiner then will have the job requirements, whatever those would be for the agency. They'll be able to make that evaluation based on everything. And then if the department doesn't like it, there is an appeal process, right? Bring in a second doctor to go through that process again, so.
Yeah.
Keeping it general like that, relying on the professional's opinion based upon the job criteria, I think, we can certainly draft that in here and make it broad enough so it fits for all law enforcement agencies.
I think Curtis, a statement of, and I apologize, Doctor, a statement of examiner's direction in there, a general statement like that would probably, that would be helpful for out the field, I believe. Something, just a general idea of everything you just discussed, and again, a general examiner's direction statement. See that.
Yeah, just to clarify too, it goes on to say, examiners integrate various data sources, assigning them relative weight according to the known reliability and validity of that issue. The range of methods and data sources used by an FFDA evaluation frequently include, it doesn't say it has to include, but frequently include. Then it goes on to say different things like review of background information or collateral information described in guidelines 7.8. And then in this case, it's psychological testing. Relevant psychological testing using instruments and norms based upon, like, for personality, psychopathology, cognitive stuff. So that could easily apply to a medical examiner, but it doesn't have to be pinpointed to specific things. It just lets them do their job. They know what tests they need to pull for this, for a medical issue, what medical issue is going on. For a psychological issue, it's going on depending on the relevant questions, the referral questions. They can then decide, what test do I give? And to your point, you don't wanna state this test and this test should only be given. It gives a broader range in that sense. And I think that will help avoid unnecessary, I guess, ruts we'd get into, or some pit holes that may be different from one agency to the next.
So if we have those guidelines in place, would that work for your, it's kind of based on your perception, your understanding of the problem that we've got to solve here? Depending upon the language used?
I think that if we're limiting the scope of the doctor's reevaluation for return to duty, I think that what Dr. Tate just described would probably work, in that you're limiting it to, is that shoulder able to perform the job functions required by the department? That's a lot different than a physical fitness or a level of fitness overall. And I think, as the chief pointed out, his department tests annually for, fitness.
Yeah, and the model policy that we have, for the proposal we have in front of us, includes a provision that says all the documentation about why this question has arisen is supposed to be provided to this medical professional. So right now, we're talking about an MD on a physical examination. So if it's because of the shoulder, the doctor's gonna know it's because of the shoulder. Now, obviously, if the doctor notes something else about this officer that makes that doctor believe this person cannot do that job, well, it depends on what that job is. So should we have one state standard? Like I say, the TCOL's gonna apply to every cop in the state, or is that the agency should send over the job description and the physical requirements for that specific job in order for that doctor to evaluate?
That's the way I see it, right? If you got a shoulder injury and all of a sudden now when they do blood pressure on him during that routine, and all of a sudden he's got skyrocketed blood pressure, it's gonna cause problems. That probably something that you don't, even though it doesn't mean the shoulder. But again, you keep this very general. We're gonna rely upon the professional opinion of the doctor who's doing the evaluation, whether it be psychological or medical.
And the needs of the department, the local staff.
Well, and even in the model policy, the first doctor seen is the choice of the evaluated. So I'm going to my doctor for evaluation, which in most cases is gonna be the most liberal person. If we have a relationship and my doctor hasn't intervened prior to now, wellness exams or whatever, if I go to my doctor right now and say, hey, I need to go back to work, I need this form, my shoulder is good, I'm likely to get that thing signed. So, now if you, the chief administrator, disagree with my doctor's assessment, then there's the option of the second, but the default is I go to my doctor and get a determination, whether it's psychological or physical, and come back with that as the first step.
Well, I agree with that. I also have a question about the qualifications of that doctor when it comes to a psychological evaluation. And so there's also some guidelines in this same proposal that outlines that. I'm just gonna give an example. Given the nature of these evaluations and the potential consequences to the employer, the examinee, and the public, it is important for examiners to perform fitness for duties with maximum attention to the relevant, and it talks about legal stuff. Then it goes on to qualifications. Consequently, it is recommended that these evaluations be conducted by a qualified, in this case, psychological, mental health professional with the following qualifications: licensed as a psychologist or psychiatrist with education, training, and experience in the diagnostic evaluation of mental and emotional disorders. Competent in the evaluation of law enforcement personnel. Familiar with essential job functions of the employee being evaluated and the literature pertinent to fitness for duty evaluations, especially that which is related to police and public safety. Familiar with and act in accordance with relevant state and federal statutes, so forth and so on. I could go on with this, but I guess we could add to, limit, but I'm just throwing it out there as you don't want someone who doesn't know law enforcement personnel if possible. You don't want someone who is not competent to give any tests that might be necessary based upon the referral question. So there's this balance of, I could go to my local medical doctor for a psychological evaluation, but that medical doctor likely would not be appropriate according to these guidelines, which I think is below minimum standards.
I understand the diagnostic concerns and the competency to have that more specialized, but I will tell you, and that's certainly a debate that can be had, but as far as I can speak on behalf of the agency, TCO, we don't have the competency to make that determination if it came to determining whether or not this was a good medical or psychological examination, because we don't have the competence or the expertise to say this person is, this medical doctor, although they do their, whatever their practice is, they are not equipped to administer this particular exam. That would be my concern with that. Colin, do you have anything to add to that?
Yeah, our current rules restrict the psychological exams to Texas licensed psychiatrists and psychologists. So you couldn't go to your general practitioner to get the psychological exam.
You could not.
Without a waiver.
You could not.
There is one provision for emergency circumstances availability. Executive director can waive that and allow an MD to do it. And I'm not aware of us having done that in years and years and years. But there is a waiver for that, but that's normally not an option. And that would have to be granted here. But I think that one thing we need to get on track is we don't see this as setting a state standard. Aside from, this is a model policy that people will have to adopt. Personally, I don't have an objection to referring to either the IACP standards as a reference, not imposing the IACP standards. And then the other, the medical is actually the College of Occupational, and I forget the source of that, but so I think we could potentially recommend the standard. So if I went to a physician who didn't know anything, they would have a standard to at least go look at. Because we're at least the way it's written, you're not imposing a bright line in the sand thing. You're diabetic, you're out. You've got a cataract, you're out. Those disqualifiers on a medical exam. You're asking for that medical professional's opinion. Can this person do the job for the license at which they have? And so I know we need to divorce physical fitness standards from the medical examination. You could impose ultimately a physical fitness standard, whether it's lift 50 pound or turn, some kind of physical standard in that. But the run, jump, shoot, and scoot stuff, I don't see that as part of the medical examination as we're talking about it, at least for the purpose of a model policy. This is a policy that's got to be adopted and executed locally. We would only be involved at that point of refusal, or as you said, a failure gets reported to us. That's
And how much leeway does each agency have on adjusting the policy?
As far as, give me an example.
We're supposed to give them a model policy, right? And they all have to adopt a policy.
Right.
How close does it have to come to the model policy
Well,
to be in compliance?
this is where I think this is where we're talking about local standards here. On one hand, we don't want to make this statewide policy, correct? If I'm understanding what you're saying, I totally agree. That's going to be very hard to do, and even if we could, it's maybe not the wise idea. But adherence to, I think, again, this is putting a great deal of control, letting it remain locally in determining from department to department what these standards are for medical fitness for their department. To what extent we go in there and say that standard is not good, is it good or bad? I don't think the model policy is going to put TCOL or anyone in the position to judge that, if that explains the answer. In other words, does your local policy say X when it should say Y according to the model policy? I don't envision what the model policy being that specific. Is if far we're talking about components of a diagnostic test medically or psychologically.
I think my concern there is, are we not talking about two different things? We're not talking about the local departmental standards that are applied at hiring, and then at what point, and can we all admit this whole thing started over the psychological stuff?
That's right.
Fitness standards. This is all about whether or not officers are mentally fit to continue being officers.
Correct.
So the time we're spending on this physical stuff, I think, is us treading water, but my concern is, isn't T-Cole supposed to be the final arbiter on this whole process?
Can be.
And if we don't have one single standard, how can T-Cole be the final arbiter over whether or not the chief is enforcing his own internal policies?
So now you're advocating for a statewide standard now.
No, well, no, I'm saying,
I'm getting confused where you, do we want it specific,
I'm saying there are two
locally, or do we want a
different
statewide standard?
I'm saying we have minimum standards to be licensed as a peace officer. We have minimum standards to be a law enforcement agency for that matter. We have minimum standards to be a department head for that matter, for some departments, not all of them. But beyond that, the agencies have every right to have additional standards in place. What is T-Cole's role in enforcing those additional standards versus the minimum requirement?
What do you think the role should be?
Well, John, I think I can talk about that a little bit, because that's what we take all the time. We take calls and complaints about police departments, and we explain that we don't have jurisdiction. That's a local authority control. Whether or not they follow their own policies is up to the agency. And the law already requires that they submit a vehicle pursuit policy, a use of force policy, all those policies, but I still can't hold them responsible for those policies. They have to have them in place. And if they choose not to follow their own policies, then I explain to them, you can complain to the city manager, you can call the Texas Rangers, you can do whatever, but I can't make them follow their policies. This is the same thing. I think the legislature said there has to be a standard that they have to adopt a policy. There has to be something in place. Now, if those agencies just simply choose to say, yeah, I'll send it to T-Cole, that's our policy, but we're not doing it. I don't think we have an enforcement mechanism for that. But there's some repercussions that come with not following your own rules, right? There's civil liability and there's
And
other
this
things.
statute doesn't create that enforcement mechanism?
We're not creating statewide standards. We're creating, the agencies have to adopt a policy and some minimum. This is the framework for how they operate. And the problem that we have right now is there are a lot of agencies that don't do that. They will hire someone as a dispatcher, they go and get an evaluation, then they decide they want to put them through a BPOC and they make them a police officer, and they're still operating under however they were evaluated, whether or not they could be a dispatcher. And when we talk to the doctors about how they evaluate, well, I don't think they could be a dispatcher in a big city, but I thought they'd be fine in this small city. Well, there's nothing that prohibits them from transferring to a big city. So is that something the doctor should have considered at the beginning? Should there be some framework so they know what it is they're evaluating? But again, we can't make them do that. We're just trying to give them the benefit of starting on level ground. Everybody's starting from the same place.
I think T-Cole only gets involved if they were to refuse.
Correct. It's an extraordinary, the way it's set up, as we've discussed. This agency becomes involved with this particular process, this examination process, in the extraordinary event of a refusal to even submit to the exam, or in the case of a failure. But locally, there should be appeals processes built into that. There should be, like we discussed, second opinions and things of that nature, and I know that subcommittee has worked on that. Or at least, I'm sure, if not worked on it actively, it's something they could look at moving forward. And certainly it's a statement that could be put into the policy to them to be aware of and also consider before it gets referred to T-Cole for submission of refusal or a failure.
Okay. My question is the failure. Because I get it. If the chief believes the individual is just simply not fit for duty, regardless of how the test comes out, they don't pass his next physical fitness standard, whatever, the chief's gonna take whatever action. Is that officer gonna lose his or her license? Because they didn't meet Cedar Park's standard.
No, that's certainly a policy question that's been in front of the committee from jump, absolutely.
Kevin, you did hit on something. There is an impact from the model policy. The statutory requirement is that the commissioners adopt a model policy, and that all individual agencies must either adopt the model or something substantially similar. So it becomes that judgment of what constitutes, substantial similarity. And so there is import in the decisions that are being made.
And is that your job to determine whether or not they're in substantial compliance, substantially similar?
Certainly in 1701, it would be, I think, something that the agency would have to review. I don't think we could decline to say, well, we can't take a look at that because, but again, I think looking at this in context, and I think we've discussed this and it's been mentioned several times, it's like any of the advisory committees. Some agencies have no framework. Some agencies have no agency standards. Some agencies have zero personnel file standards or misconduct standards. The purpose of this committee is to establish at least a reference, a framework for something for those agencies who aren't civil service, who may not have, or even though they're, may not be civil service, but still have policies. This is for agencies that have no policies whatsoever. Again, this is a positive step forward. Again, a minimum baseline for what we have for licensees in Texas.
We don't disagree. We don't disagree with the idea of standardization, we don't disagree with the idea of minimum standards our concern is a fair shake.
Absolutely. No, and that's, I think, things we've discussed as far as the appeals process to TICO, how all that works. What we're hoping to do is, and again, I think, looking at the big picture here, from TICO's perspective, I think it's and certainly, I'm no soothsayer. If not, I'd be in Las Vegas doing it there. But the type of cases that this agency will see as a result of this process, I think are very few ultimately. Very few. Obviously, just the number of themselves doesn't, it warrants, because those are the cases that are going to matter. Ensuring that they have due process, ensuring that there is a model policy that was followed at that agency level to give them the opportunity to be examined according to a common criteria that they can reference, but that's not necessarily mandated. Again, establishing a baseline for agencies and departments that have no baseline.
I think one of the things that for due process too, you talk about fair shake. So if you have an officer, if you have an agency that doesn't have a policy, they're not following the policy that they drafted based on the model policy is wholly inadequate. And you get to a point where either they refuse or they fail on a fit for duty examination. There is still, in addition to what the policy recommends, they go up to TICO and they have the ability to have a show cause hearing and potentially have that hearing in front of an arbitrator of some sort.
Right.
So in that hearing, I guess I can see it working out, saying, hey, with the chief has a vendetta against me, or what other evidence that this was an unfair process, would be able to come out during that hearing, and the right decisions made there. So.
And as the hearing, just using that, as Curtis was talking about, the hearing, the licensee gets in there and says, hey, the standard that I was held to was sky high to go back to work. And that would be impossible for anybody. There's a lot of arguments that could be made there. But again, as we've discussed before, that's where that opportunity would come up. Again, and I know all the concerns related to when we say the hearing at TICO, what we envision is this going to SOA. So that fact finder would have there, it'd be a confidential setting. You could have a full vetting of all the facts and the circumstances. And again, this is a case that would originate at the departmental level, and the facts established there would just be presented to the administrative law judge ultimately. And that's the opportunity for the licensee.
I have 70-something employees. We've got personnel policy that actually covers this. And it says if we have a concern about an employee's physical fitness for duty, we simply give them a copy of their job description, send them to their doctor, and have their doctor send us a note saying, yes, they're capable of doing that, or they're not.
Yeah.
Are we overthinking this thing?
No, I think at the heart, that's exactly the type of things that should be happening on the local level, whether it's again, feedback. Okay, just feedback. I think that's something, whether it's commentary notations, whatever it is in this policy, someone out in the field looks at this, how do I know if this person is fit for duty or not? I have a small agency, I'm unfamiliar with this, what can give me guidance? Oh, there's a notation in the model policy saying, okay, that person's job description, send it with them, or send it to the examining doctor, examining physician, let them look at it and then let me know. That's kind of, I think, when you say.
Right, and the reason I sent him over to you is because he had a torn ACL.
That's right.
And I need to know, has he recovered to the point that he can meet these standards that he was meeting before he tore his ACL? Now let's move on.
I think that's the type of guidance would be very useful for this model policy right there. Again, it's not a requirement saying you must do one, but in order to determine, send them to an examining physician, job description, have it checked out.
Well, it's not a requirement for every agency per se, but it may be a requirement for Cedar Park that before he or she can go back on duty, if it's a 100 meter road test that he has to do or a 2-mile run.
Sure.
That's part of it.
Right.
If you look at the model policy that we got last meeting, it is very broad. I mean, it just says 1016.3, it's the responsibility of each member of this department to maintain physical stamina and psychological stability sufficient to safely and effectively perform the essential duties of his or her position. It doesn't give us more broad than that. I mean, what's physical stamina in Sheriff Valdez's precinct versus physical stamina in Cedar Park?
That's right.
And at the end of the day, it's only in front of you, your commission, when there's a refusal or a failure or appeal or whatever.
That's correct.
To do that.
And the one distinction I wanna make sure we have is if they failed Cedar Park standard, they don't lose their license for the entire state of Texas because of
Yeah,
that.
But I think that's what you're saying all along, right, is that this is a minimum standard. The only way it gets to T-call is if they refuse or if there's a failure. But on the failure side, we're not talking about license revocation or suspension. If they're willing to seek treatment or they're in a, then there shouldn't be an issue about taking their license or.
And I think that's particularly important in going back to, as Kevin was talking about, this is on the psychological side where this all originates. And that's particularly important there because if you have, let's say, just using this as an example, whether it's alcoholism or whatever the case is, that's a diagnosis or the problem that's causing the person on duty. Whatever the case is, they have the opportunity to remediate that, go to rehab, get the treatment, go to counseling, whatever the case is. So it's not just a strict liability, you've been diagnosed or this is what someone has looked at and they've determined that you have a problem with alcohol, drugs, whatever the case is. As a result, your license is just going to be suspended. There are already in the statute safeguards for the licensee, so it's not just on the, there's several opinions involved, and there's several opportunities in the case of an opinion that is maybe adverse, that is the ability to remediate that and avoid license suspension.
Yeah, I think one of the things in the second draft that was sent out just recently, I think you have it in your handout, under 100.9 process for peace officers, third paragraph down, there's even a middle ground in this policy. So it says if the officer is not fit for duty, the practitioner will include the existing restrictions or conditions. So there could, if we get into the light duty, they can do this, they may do that. Maybe we don't put them in an armed position, we put them in evidence. So there's within the model policy, there's even room for that negotiated middle ground. So if the doctor says they're not up to speed to work patrol, but they could go back to be useful for the department under the following restrictions. I don't see that reported to us as a failure. Or it's not a on-off switch as far as they are one, they aren't one kind of thing. I think the policy gives enough broadness to where there's some negotiated, intermediate level. They can come back to, work the front desk or whatever, based on the broken ankle or the knee needs to mend or their pending surgery.
Some of them will get reported to you as fact.
Huh?
out of 2,800 agencies, I have a feeling some of those will get seen as failure.
I suspect that's true, and
Maybe
that's
that's
why
what
the
it's
due
about.
process is built into the process.
And Colin,
Keeping with that same, let's go one more down. Second examination may be ordered by the appropriate authority if the officer, the commission, or the chief executive officer questions the practitioner's report. Is that to mean that the commission has the ability to ask for a second opinion as well?
I think in the context of the model policy, that's actually talking about civil service commission at the local level.
It is.
So
So
that
this is
might
civil service,
reside in some policies if the civil service commission, if it was not a civil service agency, that word would be struck from the policy.
Okay.
So this hasn't touched us yet. So
Okay.
this is all internal to, Curtis, am I
You are
reading
correct.
it? Okay.
Yes, sir.
So commission
Nor
is
would
if
want.
applicable.
Yeah.
Commission is if applicable.
Right.
And Curtis, this tracks, looking at the process here, this tracks, I'm sure this is a combination of civil service, already combined ICP standards.
Tried to make it as broad as possible.
Of course.
To incorporate all the intricacies we have in Texas.
With that in mind, I want to go back to something you said, Colin, that in order to have a fitness for duty evaluation according to past policy with TCOL, it's only a licensed psychiatrist and psychologist. But in the second draft, it does list the 3 Ps, physician, psychiatrist, and psychologist. Is that something that we would not want to put in
Well,
model policy here?
I think this policy presumes the appropriateness of the licensed medical professional to the evaluation being given. If you needed more specificity, under the rules for what we call an L2, a physical exam or a psychological exam, the psychological exam is restricted to a license to practice in Texas psychologist or psychiatrist.
Okay,
So,
it's trying to capture all.
yes, I think you have
Okay.
one, I think we're driving at one policy for fit for duty.
Okay,
The examination's one of 2, physical
okay.
or a mental health examination.
And forgive me if we discussed this in our last meeting. I know that the L3 is typically for pre-employment. But are we looking at L3 type requirements for post-employment fitness for duty evaluations as well?
Well, I think that's the discussion we started the meeting off
Yeah.
Okay,
today.
oh, okay,
It is, you know, and I don't see us getting to a soup to nuts exam in terms of what tools we're using, you know. I think that the model that was given for the medical just says, look at these things. It doesn't say these things are disqualified. It doesn't say an arrhythmia is a disqualifier, but it just tells the physician to look at these things. The model policy that we drafted and submitted says that the agency, to facilitate the evaluation, whether medical or physical, is going to give up the documentation, such as the job description, as Kevin talked about. This is the job description that the employee is coming back to. Can they do this job? Okay, if they're the evidence technician in the locker, they just happen to be a peace officer, this is what the job looks like. Can this employee do this job? I think with that level of specificity, then the practitioner on the evaluator end can make some valuable judgments as to that employee returning to work.
excellent, thank you.
Are flat feet a disqualifier? They are.
Well, when we get into the psychological part, I don't know if any of y'all are experiencing this, but we're finding it hard to find doctors to do fit for duty. That will say yes or no, one way or the other.
I got to speak to two practicing psychologists who, one was a psychiatrist and one was a psychologist. I tried to speak to a third, unfortunately, he's been very busy the last several days, but the two I spoke to from San Antonio, one works for the city of San Antonio, he is the head of their psychological services. And the other is a doctor who does both entry level and appeal evaluations. So it was very informative. But one of the things that they informed me was that there are no board certified police psychologists or psychiatrists in the state of Texas. And they talked about how small the world is. They didn't say that it was an absolute disqualifier. They just said that it's better if they have experience in the police world. But one of the things that they were both on point about was regarding return to duty or fitness for duty evaluations. And they said that they are markedly different than entry level. And they both said that there's a whole myriad of facts and circumstances that you have to be aware of before you can make a determination on how you're going to administer the evaluation. And they said that there are some evaluations where they don't need a written exam. There are some that they might. One of the doctors who got into a lot more detail with me was talking about a lot of the California standards that
Yeah,
they
post.
utilize post.
Yeah.
And he was describing for me how they have like 18 or 20, there's a whole bunch of exams after the personality exams, the psychopathology that they utilize in evaluating. But he told me that there are several that are pretty common. But he said it all depends on who the officer that you're dealing with determines what exam you're going to give or what you're looking for. Because today, culturally, gender, race, trans, he said that there are so many different issues that you have to
Right.
absolutely look at the individual officer. So I think that we would be unable to put into this policy that they need to utilize these specific tests or guidelines. Yeah, I think that what they need to do is assess their patient and administer the exam that they feel is appropriate.
I can give you a specific anecdote. I had a guy, a veteran cop, applied for a job. I was doing background on, he had applied to 2 different departments. I was doing background on one of them. Both agencies did the MMPI on him. Both of them sent it off to their respective psychologists, psychiatrists, whatever. This one failed him, that one passed him. So I talked to our psychiatrist and I'm like, okay, explain to me, how is that? And he said, let me just give you a real quick example. If you're an entry level, you've never been a cop before and you're taking a psychological and you're going through that MMPI and you get to this question, or it's a yes or no, true, false, whatever. Sometimes I get so mad, I get mad enough to punch holes in the wall. He said, for 99% of the population, the answer to that is yes. Because we all get mad. We all lose our temper at some point. We get mad enough. An experienced police officer will read that question and cops think so literally, they think, wait a minute.
Get in trouble for that.
Punched a hole in the wall, and if I have not, then by definition, I've never been mad enough to punch a hole in the wall. He's not lying, he's just a veteran cop, and you have to grade them differently. And I was like, that makes sense, but how the hell do you coach that?
Yeah. I'm sorry, I think that this discussion, this last portion of the discussion, I think that's indicative of kind of the complexity of trying to create a standard statewide, as we've discussed. Again, I think local department, I do believe that, I think we could go through this and probably with those things in mind, see what fits for now, see what doesn't. Again, from what I'm hearing, certainly it seems like the local standard is the standard with maybe a statement to whoever's examining locally, this is what the job entails or things like that, if you don't have that guidance already. Again, let's establish some guidance on the most basic level for those who had, this is a hole in their policy right now, is a fitness for duty. Let's see if we can provide them something. And I think that, again, once you start talking about uniform standards across, then there are so many layers to the onion, as you have all discussed and everybody has discussed several times, and plentiful examples of what about this happens where. It's a very difficult thing, and I think while it could be within the scope of this committee, I don't necessarily know that it is a practical matter. It's something that can be executed, nor do I think it's necessarily the main imperative of the committee, put it that way.
Yeah, I just wanted to add something I already said at the beginning, and I know that we don't have a copy of this in discussing the psychological fitness for duty piece, but it is that 2018 guidelines for fitness for duty with the IACP, where it says, depending on the referral question and examiner's professional judgment, a fitness for duty examiner strives to utilize multiple methods of data sources to optimize accuracy of the findings. And then there's sections that talks about relevancy with background, examiner's qualifications and all that kind of stuff, right? Which that'd be getting into the weeds with your point, and I think, Bob, what you're talking about. But I do like the reference potential in a policy like this, that for this particular issue, or however you want to word it, you could make reference to this entire document, which they adopted this along with the American Psychological Association as well. So you have two heavyweights there that are trying to find the best course of action for a given situation, but avoiding, in this case, for our purposes here, being too specific where you're adopting quote unquote a state policy, at least making a strong reference to whatever guidelines would be helpful that could make a big difference with a person has questions about what's going on with that individual who's dealing with the fitness for duty, in this case, psychological fitness for duty.
That's a great point. And you're providing a resource for those who do not have a resource.
Right. Without stipulating you must follow this.
That's exactly right.
I think this model policy right here is reading through it.
For psychological.
I think Curtis, y'all put this together. Chief, would it be okay if we walk through it?
Yeah.
Yeah. I mean, a lot of it is civil service.
Before we
reading
walk through it,
here,
though, I'd just
yeah,
like
I
to acknowledge all the
recognize,
HUDs.
you know, so, like, okay, yeah, I'm familiar with that.
It's kind of, we've got to put it together, got a little bit of everything, so, so.
I just want to acknowledge Curtis's hard work on this. He's been our point man. He's been putting everything together, taking all of our ideas collectively, and he created this document, so thank you.
Yeah.
Thank y'all for that.
So we can claim Curtis if it goes
Absolutely.
south.
All typos.
Give him credit,
But I'd like to be on record saying Chief Harmon is the one that did the physical part of it, so.
Well, there was also a potential recommendation to have one or two buildings named after Curtis. But he said it could be just a toilet stall. That's a case of
Meeting room across plastic ones that you can carry around on the back of
As
the
long as he
truck.
gets to
take
choose the
there.
color.
Something like that. Well, and so just going through, just a general, and just looking at this again, you know, providing this to agencies and they can adopt and change it, modify it however they need to fit their own local rules or their local situation, but purpose and scope, just kind of generally what it is. Second paragraph is just the policy, what a general idea of what we want to make sure that this policy does as far as from the perspective of the agency. The third paragraph, 100.3, you know, again, these are pretty general criteria on what an agency wants to make sure that they have their employees be able to perform. And, you know, Cedar Park is gonna be different than Dallas, it's gonna be different than El Paso, so you can certainly change that and put in whatever you need. Supervisor responsibilities, you know, if we start seeing indicators as we've talked about, we're kind of from the psychological perspective, but it could work in the physical perspective also. Indicators that we've got somebody who is unable to perform the essential functions of the job. And I think that that's the criteria we're looking at, making sure that our employees can perform the essential functions of the job. And it gives some examples, although it is not limited. Confidentiality statement in there. Turning the page, a duty to report. If there's some indicators that are questionable or that are concerning. Duty status, at that point, the chain of command is gonna have to make some sort of indication or decision as to whether or not that person is able to continue to perform in whatever role they're performing. Because we've got an officer who has a cognitive issue. We don't necessarily want him pulling people over and getting in traffic. We've seen that before. And putting either himself or somebody else at risk. Fitness for duty, just a generic statement when a fitness for duty evaluation is gonna be ordered. And then we've got it broken down to talk about civilian personnel, because this also includes dispatchers or potentially detention officers, and those that may not be necessarily sworn, but they're licensees and their TCOLs criteria. So that's, and probably we'll need some guidance from TCOL as to how to best reference, I think I've got a question in there, reference personnel that we're talking about and distinguish between civilian and sworn personnel in this. And I think we kept this the same, both of these paragraphs as far as the process goes. Whenever a fit for duty question arises, what do they have to do? And it goes through the first one. Again, first one's gonna be by the officer or employee, their doctor, if there's any question or any concern, by whoever's in charge, whether it's gonna be the chief executive officer, if it's a 143 city, the commission could be, or even the employee based on that. Then a second examination is available. Again, confidentiality language in here. So one of the things we have is a statement, basically anybody who is ordered to undergo a fitness for duty evaluation shall comply and cooperate fully. And listing the potential ramifications of that. And then going into 100.9, which is gonna be the process for peace officers. It has a little different language, kind of dealing with either 143, and I think some language in there regarding collective bargaining agreements. My guess is that if you have a collective bargaining agreement, you're gonna have these policies in place, but we can strike that language if necessary.
We just need to add meet and confer agreements as well.
Yeah. Okay.
Covers everything, right?
And then once we get through that process, we've got it outlined as to what the department's responsibility is to notify TCOL in those very rare situations where you're either gonna have a failure that is non-rectifiable or else a refusal. And so the language we came up with is basically 30 days. We can certainly change that if we need to, and again, that is going to be, there is some wiggle room in there, because it's when, for example, that first paragraph under 100.10, within 30 days of the final determination, the officer or member is unable to effectively perform the essential functions of his or her job. So, whatever day that's gonna be, there is some gray area there. And the chief executive officer shall notify TCOL if a member or officer fails to submit within the deadline set by the department, whatever that deadline is gonna be. And then it shall be in writing, and submitted to TCOL within 30 days. And again, we'd probably reach out to you to figure out how you want that notification, and we could put it in there. And then also, we've got language in there, basically says that the CEO should notify T-Cole as soon as practicable if a member or officer has completed the required examination or received notice that the member or officer's circumstances have been successfully resolved, however that would be. So if there's a hearing, I mean, if we're going through the process and T-Cole is going through whatever process they are, we want to make sure they're notified if
something
circumstances have
remedies the
changed.
process
Yes.
before we get to.
Right.
And then the question is minimum standards, and based on our discussion here, we've talked about using, maybe we could put together some language that would incorporate both psychological and medical issues, and just provide some very basic language on what those standards are, and reference IACP's policy if need be.
Kind of a resource paragraph.
Yes, sir. And then finally, appeals, and so again, when we talk about just the appeal process within the city or within the organization itself, it's gonna be based upon that organization's appeal process. So they can take whatever appeal process they have and then incorporate it into this language. So that is an overview. And at least a start. Because we got till February, end of February, right?
That's right. Thank you, Curtis, and everyone who worked on this. A couple notes. Clay, you had read some language, some general language regarding fitness earlier. Do you remember what that phrase was? Do you remember the one you quoted? And it may be from
It's from your first model. It says it's the responsibility of each member of this department to maintain physical stamina and psychological stability sufficient to safely and
Okay.
effectively perform the essential duties of their position,
Got it.
his or her position.
That's in there, okay,
Yeah.
perfect. And I was just thinking as Curtis went through this, before it gets here, and I know it's permissive language regarding the agency may order or the civil service commissioner, whoever, whatever ultimate authority there is at the agency level, may order a second examination. I'm thinking if from the TCO side, we should require a second examination before receiving a referral, is what I'm thinking. And that's just me thinking aloud, but I wanna share that thought with everyone before we suspend someone's license. If they had not had the opportunity through, I know it's a permissive provision in here, at the local level, no second examination, which I don't think is going to be a common, but again, I think we're covering due process for, those rare cases that this does occur. In the absence of a second examination, my thoughts are going towards TCO requiring a second exam before us receiving the case and suspending someone's license. So it's just, I wanted to let y'all know what we were thinking from our side, and maybe that's something we put in the procedural rule as well. That's another safeguard for the licensee at the agency level.
Anybody have any recommendations in addition to the language so far proposed? Other than John?
As you can imagine, I got a few.
I would be disappointed if you didn't.
I think if we look at the process for peace officers, you would probably, I'm trying to put it in the context of the sheriff, because he's got jailers. And they have basically the same, only difference. They have a medical and a psychological burden for fitness. Telecommunicators have a psychological, but their only medical is drug screen. So that they don't have to have a full physical. An employer can make them have one, but for license purposes, they don't have to have a full physical. They have to have a drug screen.
Can we just change the heading on 100.9 to read process for peace officers / detention officers?
I think so. Or you could probably even put sworn personnel somehow if you
Yeah.
lump jailers into being a sworn positions.
Change them to sworn versus non-sworn,
I think that would,
0.8 to non-sworn. And
Yeah, I'm sorry, what
non-sworn.
was that addition?
Change 0.8 to non-sworn personnel, 0.9 to sworn personnel.
that would be reasonable.
I'd be good with that.
I think that you notated on the back, Curtis, that there was a question about changing the terms member and officer due to the fact that you have different titles for detention officers and we're also including game wardens and there's several other law enforcement officers, so.
Yeah, so I'm sure we take recommendations on how to best incorporate the, what language we best use for the model policy. Sure.
And Curtis, was it the intent of the subcommittee that this applies to medical and psychological, the framework?
So this framework does apply. What we did is we just put this together and then we left the paragraph in there, which is gonna be 100.XX towards the last, which would be minimum standards that we can incorporate based upon our discussions here.
Fantastic.
So I kind of, the way I see this is we can look at this, make whatever changes, determine what minimum standards we want, be the second question, and then the third question would be whatever TCO recommends to make sure that it comports with your processes and oversight.
Very good, thank you.
And I'd just like to throw out, based on my conversations with the doctors that I've had this week and a lot of the information that Dr. Katie's provided to us, I think that the psychological side of it is gonna be a little bit more difficult to kind of lay out an actual standard. I think it's gonna have to be more of they should be looking at this through their perspective based on their client or their patient. There was some language in a previous section, when the doctor had said, let's reference some of the guidelines or the, here it says, such indications under 100.4, such indications may include but are not limited to the following, but in the same light, the doctor recommended 2 or 3 different guidelines that or agencies' guidelines that, you know, are recommendations, and maybe we can say that, you know, they should be using, you know, what's appropriate and list those governing bodies or those agencies that you mentioned as examples to where they can look to see or get guidelines from. It's not limited to them, but
absolutely,
to kind of give them some idea or direction to look in.
And Bob, could you see that going like under the fit for duty examination minimum standards, that section, having
Yeah,
that as a resource in there?
100.XX, yeah,
Okay, great.
that when they're assessing, there's probably gonna be some. The agency has to give a written explanation both to the officer and the doctor as to why they're sending them to the psychological fit for duty. There's also gonna have to be the records, documents that are sent to the doctor to help with their initial assessment of the patient. But once they have that initial assessment, it'll be based on the doctor's practical skill set and their expert, I guess their expertise as to what actual examination protocols they're going to utilize. And, you know, we don't wanna limit them or force them to use a set of, or set of guidelines or standards. And I think the ones that the doctor recommended are a great place to look. Because as we said, there are going to be officers who have no choice but to see a licensed psychologist or psychiatrist who may have a limited skill set regarding assessing officers or deputies. It's not that they're disqualified per se, but having those guidelines pointed out to them may help them to develop a better assessment.
A more accurate assessment, certainly.
So as a possible suggestion, and then another question I had, I wanna start with the question first, under .7 fitness for duty evaluations, would it be appropriate to have a reference, at least regarding a psychological evaluation, to those guidelines, IACP guidelines? Would that be a place for that, or would we wanna only keep that in, I'm calling it 100.11, since it follows 100.10. Have the things that Bob just outlined in more detail, and then under, I'm calling it 100.12, a section for resources, where you spell out those resources, not in detail, but just reference them in that section. And then the 100.13 would be appeals. Just some thoughts there.
Sure, y'all can certainly structure it any way you wanted to.
Does any of that address the scenario I gave last time we were here about doctor shopping?
No. It's not.
Request for a second interview.
Okay.
Or for a second examination. So if let's say that officer goes to his friend who says, gives him a clearance based upon the job description, but they know, hey, you know what, there's no way he can do it. Based on what we can see, then the chief executive officer, the commission, whoever would then be able to order a second examination.
Okay.
So that would handle that problem.
Do we want to, where it says chief executive officer, do we want to include head of department, chief executive officer, head of department? Because sometimes it's the chief of police that asks for the second exam, especially, it's not the city manager or the city administrator, it's the chief that makes the determination, hey, we're gonna send you for a fitness for duty to our doctor now.
And I was using that kind of generically as the chief of police or the sheriff or the elected constable as the chief executive officer of the department, not of the city. But we can use whatever language.
Yeah, just in our world, sometimes chief executive is usually the chief, city administrator or the city manager, and the agency head or department head is the chief sheriff or constable.
That was gonna be one of my suggestions, to better define that term, because if you're working for DART or Metro, that gets really complicated, who the hell you're talking about.
And that's kind of why I kept it there, because I certainly didn't want to slide our constable or sheriff friends in there.
I think department head.
I think also this is a localized policy, so you're gonna invest whomever. When you localize this to the sheriff's department, it's gonna say the sheriff shall, or whomever.
But we are suggesting to them that it be the department.
Yeah, I mean.
Coble is on line two.
Oh my,
Somebody got a call.
I have a,
that's for
I
you.
have a question.
You signing up on aisle 4?
Somebody has a question online.
You might look at chief law enforcement officer. I think it's the sheriff.
Yes, thank you. If we're looking at sending someone based on the criteria set up in this model policy and I'll stick with psychological evaluation because that's what we're on right this minute. Aren't we sending them to our contract doctor first? So the second test would be if the employee didn't agree with the findings and got their second one.
I believe under the model policy, the employee selects the doctor first. So they're going to their choice of doctor first. If you, the chief administrator, disagree, then you would order them to go to your doctor. And that aligns with what's currently in 143 for civil service cities.
But I will tell you, that what we experience around the state though, is what the sheriff is describing, in that a lot of counties will send their employees to their doctor, the county doctor, not to the officers or deputy's doctor. So I think that's where the confusion's coming in, is that for a lot of agencies, they don't practice the 143 way. They send somebody to their, which is where I've expressed in the past a heartache, because a lot of those doctors get their resources come from the county. So we have concerns about them being biased or
So this addresses and says conducted by the member's personal physician, psychiatrist, or psychologist. So the first one would be the doctor of the individual that's going.
But that'll be a big change for the counties and for other agencies out there.
But it may be, I think that's part of the intent of this process is, you know, the advisory committees recommends this, if the commissioners take it on face and push this forward, I think that may be, Bob, one of the changes expected from this. is
We're
that-
all in favor of it.
Yeah.
Don't get me wrong, I'm in favor of the officer being able to utilize, especially if they're seeing a treating psychologist or a psychiatrist who's had a rapport and a, you know, developed an understanding of this individual officer or deputy. I absolutely support them going to their doctor first.
Sheriff, you look like you got a question.
I'm still. We made reference a minute ago to doctor shopping. Can't that happen in this same situation?
That was my question.
So what's going to end up happening is we're going to end up paying for 2 evaluations every single time, the agency. Because we're requiring them to take this test, we're giving them the opportunity to go to the doctor of their choice. And we don't agree with, which we pay for, we don't agree with the findings. So the county's going to end up paying for another one.
I don't think the agency pays for the first one.
I think
If I'm ordering Kevin to go to his personal or whatever, the financial responsibility is on you. If you come back and I don't agree with it, and I say, we want you to go here, now the department is responsible for it.
If I'm not mistaken, 143 actually specifically covers that.
Right.
Yeah, I think, and a lot of times, at least the way I've seen it is if you got a situation, if it's an on-the-job injury, you're gonna have workers' comp involved, so it's gonna get real complicated with that sort of thing as far as who's the treating physician. So if we have an officer who is injured for whatever injury they have, let's say it's a shoulder injury, and they either got it at work wrestling somebody or they got it skiing, and they had to have some surgery on it, we're going to require them to get a release from their doctor at some point. It's gonna be their doctor who's gonna do that. So yeah, they're shopping, they'll have their doctor write that note. And if the doctor says, hey, his shoulder is fine, but kind of like in the example we had earlier, he can't lift, he can't open his car door with his injured shoulder, well, that's gonna prompt the chief law enforcement officer of that agency to then request a second opinion. That will then be the doctor that will be determined by the agency. Sheriff, does that answer your question?
Y'all obviously don't live in Russ County. I keep running into this is the way it's always been done. And this commissioner's court is always of the mindset, if we require someone to do something, we are obligated to pay for that. And they get this evaluation, whether it be physical or psychological. We don't agree with the findings, and we have to go shop, and we have to go get ours. And that means we would pay for 2.
Wouldn't it be that normally if it's gonna be on the employee's doctor, say generally they'll have insurance that would cover that?
Not if it's an OJI.
If it's an OJI, then it would be a workers' comp deal, right?
Correct.
So you'd have whatever doctor they're going to at that point would still be their doctor, and actually you're still paying for it, so.
Okay. I'm just trying to get it straight in my head because I got people up the hill that's gonna ask these questions, and they're already against most things that have to do with policy anyway, so. But that's just me.
Sheriff, this is Colin Grissom. If you're paying for the first one, this policy doesn't preclude an agency from paying for the first one.
Okay.
If you're paying for the first one and don't like it and you buy a second one, you're there now. So
Yes.
This wouldn't change anything.
Okay.
But for those places, you know, if I'm injured, you know, running my lathe on the weekend, and I come in and John says you're unfit, and he sends me, then I'm on the hook to go to my doctor, bring back a form saying I am fit. And if my doctor says I'm fit, John says, I don't believe you. He sends me, he's on the hook to pay. I don't think this changes the norm in most places. But yeah, if you send them, if you pay for them to go to somebody and you don't like that answer, you pay to go to a second one, I think you're already in that position now, sounds like.
Yes. That's why I'm just trying to make it in my head, because if this is a policy, we're gonna look at allowing all of the agencies to adopt and tweak it to fit themselves, civil service, non-civil service, whatnot, then I think some substantially similar is going to, who's gonna decide to substantially similar if we're dealing with a workers' comp or we're dealing with Texas Association of Counties risk pool as opposed to civil service. Does that make any sense at all, or am I just gone?
Sheriff, I'm reading.
Wasn't that an individual agency decision?
The first doctor is the person.
Yes.
Service, you know, it doesn't. Second one is by the agency. Okay. Yes. Jurisdictions. Okay.
So what's the question?
Not exactly sure. There's some sort of non-permanent
Dictating the doctor. Personal position.
Do you know what this risk pool thing is that he mentioned? Thing that he just mentioned? Is
The
that
TAC is their risk manager. Texas Association of Counties. And
so does it have any sort of conflict with his?
I don't see conflict.
Okay. Well, if you don't, I won't.
That's very good.
Oh, yeah.
Are we working or something?
Sheriff, I don't see a conflict. This is something that we want to have you, each of the agencies run past their legal support, certainly.
Correct.
If it contradicts an existing policy, we'd sure like to know what the contradiction is.
Yeah.
And the source of it.
We were currently working on a fit for duty policy. It has not been completed yet, but it's certainly something that with our TAC legal here is Flowers Davis out of Tyler. And definitely something I'll make sure that that they can agree to before we start tweaking it to fit us. I don't have any issues with this model policy at all, except for that it does need to be tweaked for individual agencies, not one size fits all, because for obvious reasons, we've already covered that we're not going to be able to do that. And still be within the confines of what the legislature wants us to do.
John?
John?
So which section are we talking about here? And we're talking about who is paying and who's providing the examiner, if I understand. I just walked in, so.
Yeah, 100.9 first paragraph. Examination shall be conducted by officers, personal physicians, psychiatrists, psychologists.
Maybe to cover, if they're existing, and Sheriff, see, let me run this by you and see if this works and you as well, Constable, if a department, maybe on the exact local procedures, in the absence of whether it's civil service or if there is an appropriate county type policy, statewide risk management, risk pool model policy, which they have, I think certainly we can accommodate, and the purpose of this will be to accommodate that if there's an existing policy. I think this is really speaking to in the absence of a statutory or established policy. That would be my thought. So that way we're not stepping on the toes of an existing county policy or a risk pool policy or anything of that nature. Would that help? Does that help at all?
Yes.
So maybe we can add that to the language here. At least we could operate under that language in order, because obviously there can be varying policies that exist now, but I think if everyone else it feels comfortable with this, as long as there is a policy, providing some sort of due process and the appropriate diagnosis.
Correct. Because even, with the CLEAT representative and a TMPA representative, I mean, they can tell you story after story of the huge differences between municipalities and sheriff's offices and constables when it comes to the way some of these policies are drafted, or even more importantly, if it's an accredited agency as opposed to a constable's office or a sheriff's office. There's a lot of differences. Policies may be similar, but the way it's worked is different between those agencies.
Absolutely.
Just changing the order of conducting this evaluation is substantially similar. You're just changing the
Is there anything in the model as presented that on its face is objectionable to any of the committee members, I guess would be one way to look at it?
No. I'm sorry, what was the question again?
I said, is there anything on its face that you just object to any section or any requirement in this policy that just has a strong objection, or are we on the right path and just keep?
I think there's a number of things that I think we would like to discuss as possible tweaking.
Okay.
But as far as just absolutely objecting to it, no.
I don't have any objections. I just had a clarification to something that you brought up prior to the sheriff's concerns. And that was if and this is regarding psychological fitness for duty, if an officer and for that matter, a civilian chooses their personal psychologist or therapist for fitness for duty, that cannot be done. It would be a conflict of interest. For a medical evaluation, probably so, that's okay. But if I'm treating someone as a therapist and then they come to me, say it's an officer, hey, so-and-so happened, they're asking for me to have a fitness for duty evaluation, can you do that for me? I might professionally have the ability to do it, but I have to recuse myself and allow a third party to do that evaluation. Because there's an automatic, whether I could try to say I'm being as unbiased as possible, there's an automatic bias-y, if that's the right word, bias, for me to do it. And for example, if I say they are fit for duty, that person is probably very happy. However, if I find evidence that supports they are not fit for duty, they will not be happy. Unless they're very objective and holier than thou, and they're saying, yeah, you're right. It just presents a mess. And now you're putting your license on the line according to guidelines and bylaws and regulations for the state of Texas for licensed psychologists.
That would be an ethical violation.
That would be an ethical violation.
So, and I think in those situations, that kind of solves itself, because I don't think we have to, we don't have to incorporate that in the policy, because if some medical professional, whether it be a doctor or a psychologist, commits an ethical violation in whatever they do, there are ramifications for that.
And I know that, but I would guess a lot of people that aren't licensed and under that rubric of ethics, they might see, oh yeah, that sounds good that your personal psychologist is going to do this because you know that they know you well. Go ahead and do that. I would imagine if I talk with many different police agencies and they didn't know the requirements that we have and obligations we have, they might say, yeah, that's fine. And they would never file a complaint against me. The time when they'd file a complaint against me would be if I say they are not fit for duty, and then their lawyers get involved and say, oh, because you know how good lawyers are, they'll look at your own policy and hang you. You'd get hung.
I think what the policy points to is that the selection of the practitioner is on the employee who's had the request made of them. So arguably, a professional such as yourself would recuse themselves or not take on that role, probably make a referral. But it's still the individual who's subject to the fit for duty gets to choose the source of the examination.
Yeah, I have no problem with that, the choosing. It's for just to be plain, it's more of an ignorance issue on the part of the person choosing. They may not realize that. Now, and then there might be ethical issues, and I know we're getting in the weeds here, with the psychologist that says yes, knowing that it's an ethical violation. But that's a whole different issue.
I would say any lay person going to a licensed professional, agreed, they're not going to know the ins and outs of the ethical responsibilities, whatever the profession is. That's going to have to lay in the hands of the professional to know the canon of ethics and exercise them accordingly into a situation like you talked about.
Yeah.
I don't know if, and I think that's, was unaware of that type of dilemma out there, but I do think that's probably beyond water's edge for what we can accomplish here.
No,
So-
and I realize that, I just wanted to put that out there so that this committee is aware
Sure.
of that. That is and it, you know, I'm not saying that a therapist, and when I say therapist, a licensed psychologist too, could not do a good job with providing the actual fitness for duty evaluation, right? But if they're honest and they're trying to follow their ethical guidelines, they should recuse themselves if asked. And to give you an example, I've been at HPD for 18 years. I've probably had a handful to 10 to 20 people in this time frame that were supervisors who said, hey, can you do the fitness for duty evaluation for X officer? Not knowing that we can't do that as a division, even though we have 8 licensed psychologists, but we can't do it because it'd be a conflict of interest. But if they came to me privately, in a private practice, and me working there, I couldn't do it. You know, if I was already treating them, but I can't do it anyhow, even in my private practice, working for that agency. Now, if it's someone outside of the agency, yes, but not within the agency, because it's a conflict of interest. And it's gonna present a lot of can of worms and legal issues, and I would have a complaint filed against me and I would lose likely, and I don't know if I'd lose my license, but I probably have a stiff fine. And I wouldn't like to give up that money, because I think I told you, my wife and I have twins and triplets that are draining our piggy bank. Wow. Bob, if you can help out, you know, great.
Kevin, you said you had some recommendations?
We got time to go through them?
We're here.
Okay, well, I'll go through these as quickly as I can. 100.3, and this is repeated several times where it says either safely or safely and effectively. Our suggestion is take out the word safely and just go effectively in all those instances.
Kevin, where are you at right now? I'm sorry.
100.3, the first sentence says sufficient to safely, and then the first, like I say, it's repeated several times where it says either just safely or safety and effectively. We suggest just go with effectively there. Law enforcement's just not a safe environment to start with, so. The second portion of 100.3, during working hours, all members are required to be alert, attentive, blah, blah, blah. You've been ordered to work an 18-hour shift, you got held over because somebody called in sick, you know. Does that really need to be in this policy? Is that going to a fitness for duty question, or is that more of a separate policy somewhere? Is it, you know, we just don't think that's necessary in the context of what this policy is trying to accomplish. The next one says any member who
Go back, where'd you say that was, what paragraph?
Second sentence. 1.3.
Take out the whole thing is what you're looking at?
That's why our argument is that's not part of what this policy should be about.
Like employee handbook or something
Right.
separate, yeah.
And the next one is kind of similar to that, is any member who feels unable to perform. If you're gonna have that in there, we would suggest it say any member who is unable to perform it. Then safely is in there again, like I said, we think it's just limited to just effectively. 100.4 got the same thing. Under 100.4, by the way, you got the criteria, you know, limited but include but not limited to. First one says abrupt or negative change in the member's normal behavior. How about usual behavior? Because otherwise you're expecting me to understand what is normal for somebody else, and I can't really tell you that. I can tell you what's usual in my experience, but what's normal for them may not be.
No, I see what you're saying. What do you believe the difference would be between usual and normal?
What I have usually experienced, what I have usually seen from them, I have a limited amount of exposure to that person.
Well, correct me if I'm wrong, but wasn't this for the immediate supervisors under their direct supervision, not administration?
It is, but in some departments, I may be their immediate supervisor one shift a week, or, you know, a couple of hours a week. I still have the same duty to report under the next section, which I've got a whole bunch of stuff on that one. Anyway,
Well-
that's just a suggestion. That may be something we, deal with somewhere down the road in practice, but the word normal just didn't seem quite
Usual or normal behavior, like we
usual, I think. Usual or normal, okay. Typical behavior,
Yeah.
anything that is a deviation from their norm.
Would expected be too strong?
I don't know if I'd like expected.
That's
That's a
Yeah.
standard.
That's,
Yeah.
that puts a.
Too strong?
Yeah, I
Yeah.
think so.
Alright.
Reminds me of a joke, by the way.
In 100.5, the word safely is in there again, so I've got it marked. But then it goes on to say, report of a member who is perceived to be unable to effectively perform. The question there that I wrote down is perceived by whom? And exactly what are we trying to accomplish there? And then I also wrote down this question with regard to that. Is the supervisor going to be judged on what he or she perceived, or on what someone else perceived, or on what someone else believes the supervisor should have perceived?
Yes, yes.
All the
But I mean, that's true of any supervisory position.
So
I
you're,
don't think this imposes something new on, I think the gist of it is to, especially in the first paragraph, if they perceive someone's unable to perform, and I think there's some potentially 99 out of 100 people would all agree that employee should
Then
not be on the
then
street
let's use
today.
that standard, just like in an affidavit. If you have reason to believe, then report it.
Set up perceived,
You
Kevin?
have reason, whatever your reason to believe is, report it. For a supervisor who has reason to believe, submit it.
Give the sub language again, please. What's your substitute language again?
A supervisor who has reason to believe that an employee is unable to effectively perform his or her duties shall promptly document.
I think your suggestions will actually make it easier for frontline supervisors, because that's the standard they're used to in articulation. I
Correct.
can't tell you what normal is. I can tell you what they usually do, and I can tell you how it differs now.
Right.
I can tell you the reasons I believe they can't perform these duties.
Between then and now.
That's what they're used to articulating, so it'll
Right.
be more comfortable for them.
Right, just like, probable cause. We know how to articulate what our probable cause is. I have reason to believe, and I do believe because.
I can't tell you how it should normally act. I can tell you what it usually does and why it's different.
I also had the same question Bob had about what's the chief executive officer. That's already been covered. Under the 100.6 duty status, obviously being the labor advocate here, I'm talking about relieving people of duty. Should we not recommend that if at all possible, those employees be allowed to utilize whatever accumulated leave they have available to them, place them on FMLA, et cetera, so that this doesn't come across as punitive? This is supposed to be an attempt to help them get whatever help they need, treatment, whatever, to address their circumstance. So should we not at least recommend that this be administrative, paid, sick leave, vacation time, whatever they've got accumulated, they're allowed to use it, rather than unpaid?
Wouldn't that be a local?
I was gonna say.
I'm just saying, from a recommendation standpoint, coming from the state of Texas. Obviously, you can't mandate it.
Yeah, but this doesn't address how they're gonna be placed on leave, so that's gonna leave it up to the agency. And I think we start injecting that sort of stuff in there, it kind of gets away from.
Does it, maybe I'm just not reading it correctly, but doesn't it say that it shall comply with the administrative leave provisions set out by departmental policy? So,
Yes,
I mean, if we
But some
strike,
departments administrative leave is paid, some's unpaid, some it's both.
well, yeah, I know.
can we strike administrative, is that, I mean, just the leave policies it's gonna be left to the local agency.
Appropriate leave policies,
I,
because if they're going out sick,
that's
then it would be
broader.
the sick leave policy. And then you have, on the psychological side of things, you have the issue of whether or not it's workers' comp. Because if you're out PTSD, or PTS, the D is dropped now, but if you're
Well,
out
now you
PTS
have-
because your partner just got killed in front of you, that would be covered under workers' comp.
And there's
That was
some
sick.
mental health leave,
Yeah,
you know, now that agencies are obligated to have policies on
Yeah.
mental health leave. And so I think if you just broaden it to appropriate leave policies to the department.
Well, but understand what that sentence is only putting an obligation on the employee, not the employer. That specific sentence is only saying the employee shall comply with the leave policy, not the employer. And I took that as saying, you can't work extra jobs, you can't do, you can't go out and act as a peace officer while you are on administrative leave. That's my experience with administrative leave.
Right, I don't know of anybody that is allowed to work in
Right.
part-time while on administrative.
Correct, but it's only putting the duty on the employee. I'm only saying, should we not be trying to convey that this should not be a punitive process by placing people on unpaid suspension while we're trying to figure all this out? And if we're saying we believe as employers that there is something physically or mentally wrong with you, are we not getting family medical leave involved anyway? Or we're not getting maybe even ADA
Potentially,
involved here?
Yeah.
Does HIPAA, I know you brought this up, does HIPAA start playing into some of this?
And maybe to address that, and I certainly hear what you're saying regarding, the way it reads now, it does seem like it's putting a duty on the employee only. And maybe where we're not framing it as a employee shall comply with, but have all applicable leave policies, I don't know, if for an employee placed or relieved of duty, comma, all applicable leave provisions. I don't know, something to that effect where it doesn't seem like it's some duty put on the employee. Would that help relieve some of these concerns?
Can we lose that sentence in its entirety without corrupting the?
I don't think it's, the document itself, or certainly the main heart of it, is not corrupted if that were gone in its entirety. Curtis, do you have any?
There's gonna be a policy with regards to
Yeah.
this, so we can just strike that.
Strike that sentence? I'm fine with striking that sentence. Like I say, that, my other question was about the paragraph before that, about the appropriate supervisor should immediately relieve the member of duty pending further evaluation. And I don't, maybe you do put something in there according to or according to appropriate policy or something. Anyway, I felt the duty to bring that up. The other thing I have was about the meet and confer agreement. You already covered that. I got through them pretty quickly.
That's good, that's it?
That's it.
Oh, man.
With that last part that you said, Kevin, were you saying that the appropriate supervisor should immediately relieve the member of duty pending further investigation according to respective policies within the agency?
Yeah, pursuant to policy or something along those lines. I would hope that most employers in this circumstance will make this paid leave at least until you've got a little bit further into this process. I know some won't, and some can't, some just don't have the resources, but.
I'll make those changes.
Okay.
Send it to you guys to send out to the committee if that works out.
Good with you, Chief?
Sounds good.
Constable, good with y'all?
Good with me. Yes, sir.
Any discussion on that?
Well, I just wanna reiterate on 100.7 that if there is a revision, I'd like some consideration to be given to a reference to the IACP guidelines, how it's worded, we can, go with that. And
Are those the same guidelines that we were talking about referencing in 101XX?
yes,
And I wasn't actually talking about laying out all the guidelines, I was just basically saying like IACP
right,
or California Post or
Right.
whatever you're gonna list out as reference, for the doctor to look at. And it's directed directly at the doctor, not the department and that's what I'm concerned about putting it here in the section that you just mentioned, Doctor, under 107 or 100.7 is that I think that by putting in medical guidelines or medical descriptors to chief sheriffs, constables, heads of departments, we may be getting a little far foul of I don't wanna give somebody, the problem I have is when lay people tend to look at professional standards or guidelines, they always seem to be able to make something fit. It's like people who Google treat themselves medically, well, I have this disease, well, it's found in like less than 1.1% of the population and you have to live in, some rare tropical place for the last 5 years, but they fit all criteria. That's what I'm afraid of, is that if we're leading by suggestion, people are gonna find something that fits.
One of the other advisory boards or committees, whatever we're calling these things, has the task of setting the minimum standards for law enforcement agencies. And one of our guys is on that committee, he's been asking me, so how do we determine whether or not a local governmental subdivision has the financial resources to actually operate a law enforcement? And maybe we just found it. They have to be able to have a psychological expert on staff. A department psychologist. If you don't have a department psychologist on staff, you can't have a department.
Just shut down 3/4 of the agency.
And tell me the downside to that.
People won't have
We're not gonna get too much.
You want me to add that as a Kevin Lawrence clause?
Absolutely.
And legal counsel on staff.
Absolutely.
well, to your point though, Bob, are you not doing the same thing by referencing it at the end? And you're referencing the same thing,
My reference at the end was for the doctors.
okay?
In other words, so if you're looking at 100XX, whatever it was that we're
Right.
talking about, that's just a suggestion to the evaluating physician or psychologist, that you may wanna reference these areas for suggestions regarding how you conduct your evaluation. But I'm always reluctant to put those levels of professional guidelines in the hands of lay people because like I said, without the proper training to evaluate or assess those guidelines, if you don't know what they really truly mean, you can make a square peg fit in a round hole real easy. I would rather just, if we have to find a solution for heads of agencies to make those determinations, I think we need to come back into our world of policing and see how chiefs and sheriffs, how we've been doing it and see where we can tweak that if we need to.
Mm-hmm.
One of the biggest issues I've always had over the years is I've seen it abused way too many times. I've seen people retaliated against with fitness for duties, with especially psychological fitness for duties. That's a big one for retaliation. A chief, a sheriff, a constable, just send somebody out for one because they don't like that person. They kind of screw up their life for several weeks, a few months.
How about us four, Crawford, we can get together and come up with the language?
Yeah, if you want a subcommittee,
Yeah, we'll have another subcommittee meeting.
sure.
In what part was this again? Okay.
It's 107 and 100, XX, fit for duty examination minimum standards.
You're gonna come up with a solution to situational ethics. I can't wait to see.
Chief Harmon, if you got any
You do
medical
that,
stuff
we're
that you wanna
gonna
put in there, we can
go.
Yeah, put my best union hat.
Yeah, I think they're based on the documents that Dr. Scheinberg sent in, they may wanna reference that American College of Occupational and Environmental Medicine, kind of a similar LEO in corrections, they've got several occupation related standards. Not imposed as standard, but refer to them as a resource.
Subcommittee, I think you might have been the chief on TV.
anything from T. Cole you'd like me to address or us to address as we're moving forward on this?
Yeah, I think is what you guys have come up with in this document, I think that's a great leap forward today, no doubt. Thank everyone for their input. What we would like to do on our end, as we discussed earlier, Chief Curtis Constable, send that to us once you guys, the subcommittee, and all the changes are made to the model policy. What we'll do on our end is incorporate what we discussed today, and we'll come up with the procedural rule for y'all's review. Once, in the rare occasion that once all of the local examinations, refusals, or failures occur, what that will look like when it gets sent to TCOLA and on to SOA. So we'll have that, we'll circulate a copy of that rule within the next few weeks, probably about the same time you get done with the amendments to this, and we'll go from there. Excellent. So we'll have a model policy and the rules, so we'll have a complete package put together.
And I do think there's a little bit of procedural stuff that could be added to the model policy, specifically the notification. They have to provide to the licensee written notice of the examination that includes the reasons for the examination not later than the 10th business day before the deadline to submit to the examination. That should be in the model policy.
Could you give them the site on that, Aaron?
Yeah, it's 1701.167A 2. Just lost it. A2A.
2A, okay.
167.
167.
All right.
That's a good point, because that's in the statute, so.
Mm-hmm.
Okay. Good.
Anything else? Those two topics?
Nice looking at the chairman.
Set up our next meeting.
I have a question.
Yes.
Somebody had mentioned the possibility, due to our shortened deadline, we learned that we have to actually be done by the end of February. Do we wanna set 2 days in January, just in case?
Could. It's to your discretion.
I'd just like to get it on the calendar, so if I have to schedule things throughout the month, I have to schedule things.
Sure.
I think Sean brought up earlier conversation about morning times. If that works for anybody. John, do you want to talk on that, or?
Yeah, and I only brought that up because we were gonna be looking at January, February, and have the potential of weather and different things of that nature. If having an issue with that, depending on when we were going to meet, if having something in the morning hours would allow to travel down the day before meet and then have plenty of time to travel back before nightfall, depending on how, like I said, the weather goes. But if 1 o'clock works for everybody, I have no problem staying with that, but I just knew we were gonna be on a time crunch, having a couple more meetings, and I think probably having one meeting in January would be fine, and as we've progressed, and if we see that we have to do more than that in February, we could, but like I said, I'm fine with either. I was just thinking that we start seeing some potential bad weather in January and February, so if we needed to look at changing up times.
Is bad weather in Texas like 31 degrees? I'm from Ohio.
There's a hint of a snowflake.
Yeah.
It's David Jones.
I laugh when I see like, oh, it's cold and it's raining.
Yeah.
The entire city shuts down and it's like, wow,
Any
I've
snow
had to go to work with
whatsoever.
2 feet of snow.
However, in their defense, the panhandle
Yeah.
and west,
Yeah.
they get freaking blizzards
Yeah.
out there, so.
Yeah,
That's what I was figuring.
Dallas is certain.
If a snowflake drops, that's
Yeah.
it. Shut her down.
If we do have something here, we, in Austin is susceptible to ice storms. That's true too, so that's no joke, but.
Well,
No offense intended.
Understood,
No,
no, understood.
Batteries and.
You're assuming Houstonians can drive in good weather.
Yeah.
So what date do we want to look at in January?
Thursday, the 11th, does that seem to work for people?
Thursday, the. That's not on.
We may have something, let me check here for. We have, okay, great. We have the 10th for our misconduct committee here, just throwing that out there. So the 11th, we have open.
What time we're looking at?
I'm good with 1. Travel. 1 o'clock.
That was January 11th.
Correct. January 11th, 2024 at 1
Scheduled
PM
tonight.
here.
Do what? Oh, yeah, we'll get that.
Are there any public comments? You don't have a list of people on hold? All right,
They were, they're all probably hung up on it.
no objections, and we will adjourn.
Thank you, everybody. Appreciate it, y'all.